Yes. Well, spectabulis, dear Pavel, thank you very much, not only for the ad hoc introduction, but also for offering me the honor to speak in this very prestigious series, and for providing me the cause, not the reason, because the work of Leona Petrażyckiego is reason enough, but it provided me with an occasion to peek into Leona Petrażyckigo's works, and it was quite a discovery for me, I have to say. My talk tonight will center on some discoveries that I made in my own work, which confronted me with a question I did not set forth to answer, and which is, in a way, also above my disciplinary pay grade, but which I want to address anyhow tonight. For the last about a dozen years, I engaged in a project of an analytical reconstruction of legal hermeneutics. It is the attempt to draw on different discussions in analytical philosophy to give the best account of what lawyers actually do when they apply the law. I was driven to this project by a curious state of affairs in legal theory. But let me start with a more commonplace observation. In many cases, the law seems indeterminate. Our higher courts and doctrinal legal academics are usually only interested in cases in which the hermeneutic tools at our disposal do not seem to suffice to deliver a single right answer that can count on widespread intersubjective agreement. For me, as a constitutional lawyer, cases like abortion rights, death penalty, the protection of hate speech, data protection, and legions of other cases come to mind, in which debates are raging for decades with no end in sight. And different from the sciences, none of the participants in these debates could even name a fact that, once discovered, would settle the issue. In physics, the existence of the Higgs boson was disputed, but the participants all agreed on the kind of data it would take to settle the issue, and the Large Hadron Collider in CERN delivered. In many of our constitutional debates, there is nothing analogous to the Large Hadron Collider insight that would allow us to settle our issues. This phenomenological, and I think also theoretical, indeterminacy of the law is not a secret only known to lawyers. The public knows. They too have no illusions about the determinacy of the law, as is testified in German language by a couple of proverbs. I just named two. One goes, in front of a court, and on the high seas, you are in God's hand. The other, even more brief, 2 lawyers, 3 opinions. The indeterminacy of the law suggests a fairly straightforward inference that has been made more or less universally in legal theory, not only across the ages, but also across different legal cultures, such as the German, the Anglo-Saxon, the French, the Scandinavian. The inference goes as follows. If legal materials and legal methods do not determine the decision made in a given case, how can the decision still be a legal decision? If legal criteria are exhausted, its decision must be made with the help of other non-legal criteria. From this inference results what I call the common assumption in legal methodology that adjudication in cases in which the law is indeterminate can no longer be considered a legal decision, but is the exercise of some kind of political, ethical, moral, economical discretion. Kelsen, Hart, all of them. go down this route. In different strands of legal theory, this assumption is taken up in different, even diametrically opposed ways. At the one end of the spectrum are one right answer theories. They try to avoid the inference by denying its premise, namely that the law is indeterminate. Were it indeterminate, they would also come to the result that it's not a legal decision. That's why they are fighting so much to get the one right answer. On the other end of the spectrum are the more or less radical crits, who argue for a radical indeterminacy of the law and its thoroughly ideological political character. Most theorists, but probably I think also most lawyers, however, are somewhere in the middle, in the mainstream, not denying the indeterminacy of the law, but trying to marginalize it. The few hard cases, as they are called, of legal indeterminacy resting on a mountain of legal determinacy. I was dissatisfied with all of these answers. The thorough determinacy, the one right answer theories of the law, they are not only phenomenologically unconvincing, but I think also theoretically. I won't go into this. I would guess that you would agree on the phenomenological side. The same holds for the radical indeterminate thesis. Every red light, stop sign, speaks against a radical critique. We all know what we have to do when we see one. So that leaves us with the mainstream, towards which most lawyers, I think, are drawn. Accepting indeterminacy and the non-legal character of decision in these cases, but relegating them to the margins. The trouble with the mainstream is that the cases pushed to the margins, the so-called hard cases, are the only ones higher courts, legal academics, and our academic legal education cares about. H. L. Hart correctly observed, quote, hard cases are the daily diet of the law school. And if there are students around, they will probably agree. The marginalization strategy dismisses the heart of the professional legal doctrinal practice as a large-scale charade. The monstrosity of this claim is not an analytical argument against it. As little as atheism is defeated because people have built cathedrals and fought wars in God's name. But the monstrosity of the marginalization strategy has to be made explicit. One has to be clear what one is talking about, and should let us think twice. If there were an alternative to explain our legal practice in hard cases that avoids the monstrous claim, that should count in the favor of this explanation. Now, I won't go into any details. I just give you the upshot of my hermeneutics project, and it is that there is such an account. It can be shown that the development of legal doctrine is a specifically legal project, even in cases in which the law is indeterminate. Amending the law by doctrinally developing it in cases of legal indeterminacy is a hermeneutic practice. The doctrinal developments have to be justified by reverting to a text of the past. Oh, can we switch the outline? Next slide. Yeah, that's probably helpful. I thought I'd give you an outline, so once you lose track, and then when you wake up again, you can see where probably where I got stuck, or where you got stuck. Okay. So, and I'm discussing why legal decisions in hard cases are still legal decisions. And the first reason is that it's hermeneutic, that amending the law, developing it in cases of legal determinacy is a hermeneutic practice. The doctrinal development they have to be justified by reverting to a text of the past. And this text can be a constitution, a statute, a bylaw, or a precedent. And we have to attribute communicative intentions to the hard case at hand, to these texts that are prior to the case. And that is quite different, for example, for political decision on the same topic, which is not restricted by references to texts of the past and does not have a hermeneutic character. It can have a purely pragmatic character. Further, doctrinal developments of the law have to be justified, and they have to be justified within a specifically legal doctrinal sphere of argumentation, which comes with very specific doctrinal inferential commitments. Let me just highlight three aspects by which what Max Weber called the dogmatics of meaning in law render decisions in hard cases specifically legal, even though they are not determined by the legal materials or methods. First, decisions in cases of legal indeterminacy are influenced by attitudes of the decision makers. But there are specifically doctrinal attitudes and dispositions which influence decisions in cases of legal indeterminacy. A certain judge might lean toward a more formal or more material reading of the Constitution, or a more federal or unitary reading of the same Constitution. Attitudes like these do not influence economic, ethical, or political decisions. Second, the decisions insert themselves into a specifically legal network of doctrinal inferential connections and have to take these specific connections into account. And this, I think, is the main reason why we have academically trained lawyers. We train them on hard cases so that they learn how to develop the law within this complex inferential doctrinal network that the law provides, and so that they don't amend it and wreak havoc on this network. And this is something only lawyers can do. Only people who overlook the whole inferential structure can do this. No economist, no philosopher can do this. That is why Jürgen Habermas is not on the Federal Constitutional Court in Germany. But my colleagues are. Third, the inferential connection in law and connections in law are specifically rigid, which is why Robert Brandom picked the law to demonstrate his concept of material inferential connection and the scorekeeping that goes with it. In law, the inferential connections are fixed. Are fixed by explicit rules. If we qualify an utterance as the formation of a contract, a whole slew of legal consequences are attached to this decision. And they are attached to it by explicit rules of civil law. The law does not allow for cherry picking, or at least it makes it much more difficult than in other areas of discourse. So I'm quite confident that I'm able to explain what gives decisions in hard cases a specifically legal character, even though the law is indeterminate, and thus explain better than the mainstream what higher courts do and what we do as academic legal teachers in doctrinal law, and what students do at our faculty, what they actually learn. They do not learn an ideology, but they learn to work in this inferential network. Just to be clear, autonomy doesn't mean independence. So the autonomy of this legal sphere of argumentation that is developed by these inferential connections doesn't mean that it isn't influenced by factors. Autonomy is always a gradual phenomenon. We conceive ourselves as autonomous beings, but we all live under certain constraints, economic, relational, professional, etc., and we have to take them into account. And the same holds for the autonomy of legal doctrine. That its development has some autonomy does not negate that in cases of legal indeterminacy, it cannot be under the influence of other factors. Which kind of development of legal doctrine lawyers embrace, or in which direction they develop the legal doctrine, can be influenced by political and ethical attitudes. However, as numerous so-called attitudinal studies, who study the attitudes and the influence of attitudes of judges, especially in the US, on legal decision making, have shown there is no straight line from a political attitude to the support of a certain legal doctrine. The influence of political attitudes on court decisions is measurable, but it's pretty limited and cannot account for the vast majority of decisions in hard cases. So, it seems all good and well, as far as my critique of the common assumption and the defense of the legal character of decisions in hard cases goes. But isn't it a curious state of affairs? In the time of the name of the sponsor of this talk series, early legal sociologists like Leona Petrażyckiego were flabbergasted by the phenomenon of an autonomous legal doctrine. They took aim at the arcane practice of doctrinally developing the law. After the humiliating defeat of France by Germany in 1870, François Génie saw one of the reasons for the inferiority of French society in the petrification of French law in the so-called L'École d'Exégèse, which tried to stick to the most literal meaning of the Code Napoleon. Génie thought that the adherence to outdated legal doctrines stifled economic and societal development at the advent of industrialization and left France defenseless against the Germans. He and others, who were succinctly called les juristes inquiets, disquieted by the petrification of legal doctrine, called for an opening up of legal methodology to the advances of the emergent social sciences such as economics, sociology, and psychology. The point was maybe put most succinctly by Eugen Ehrlich. Eugen Ehrlich was a kind of a kindred spirit of Leona Petrażyckiego in more than one sense. He was not only one of the first legal sociologists, but also shared Petrażyckigo's disdain for the scholarly legal establishment and also for some of the same reasons. Like Petrażyckiego, he thought that the fixation of his contemporaries on state-made law was a big mistake, oblivious to the history of law. And although his distinction, Ehrlich's distinction between law and other social norms by, as he called it, Gefühlstöne, emotional responses of the participants is less precise than Petrażyckigo's rights approach, it is conceptually very close. All these similarities have even led to the suspicion that Ehrlich must have stolen some of Petrażyckigo's ideas. But it seems that no direct intellectual connection is at least obvious from what I read about the two authors. Now, like Génie in France with the École d'Exégèse, Ehrlich was confronted with a similarly formalist tradition in legal doctrine in Germany, conceptual jurisprudence, which developed in the wake of the historical school founded by the old towering figure of Carl Friedrich Savigny. Like many other later critics, Ehrlich at least took them to believe that the law consists of a pyramid of legal concepts that allows doctrinally trained lawyers to situate cases in this conceptual scheme and thus come up with determinate results for each and every case. Lawyers of this tradition, such as the early Rudolf von Jhering, compared conceptual jurisprudence to natural history. Just like a fully developed system of species allows the natural historian to assign a newly discovered species a systematic place in the system, a new legal case could not surprise a well-trained lawyer. Scholars of the historical school had developed a system of legal concepts out of more than 2,000-year-old history and tradition of Roman law. It seemed unthinkable that a new case would arise that could not be assigned its place in the system that rested on millenniums of legal experience. Eugen Ehrlich would have none of it. First, he drew attention to what he called gaps in the law that would necessarily arise out of the limitations of human foresight and the changing circumstances of the times. Unlike the mainstream of his time, he believed strongly that the law was necessarily indeterminate in many cases. Second, he believed that filling the gaps by hermeneutic means of legal doctrine is a foolish idea. He bemoaned one of the great achievements of doctrinal law of its time, not because for the resulting doctrine, but because of how it had to be achieved. Buddha von Jhering had worked on the fragmented Roman law on pre-contractual obligations. From the exegesis of many Roman law cases and the comments and glossaries of famous Roman law scholars, he extrapolated the general doctrine of culpa in contrahendo being limited to the negative interests of the parties. Jhering's doctrinal discovery was much lauded and a great success in German civil law. Ehrlich too thought that Jhering's idea made a lot of sense. However, he asked, and I quote, "What pitiful citation Jhering deemed it necessary to furnish in order to make palatable to himself and also his contemporaries one of the cleverest ideas, the theory of negative interest in a contract." End of quote. Instead, like Genie, he recommended filling the gaps not by relying and being restricted by pitiful citations, but by relying on empirical investigations into the best practices and solutions which could be discovered by sociological methods, some of which he invented in his early legal sociology studies. And I think Ehrlich has a point. Why should courts rely on arcane-seeming hermeneutical methods to amend the law in cases of legal indeterminacy? Why should we go through the pain of developing an autonomous legal doctrine to guide us in deciding the most practical and pressing questions, thus restricting and limiting the guidance by superior knowledge and practical expertise? Why not confess that the law is indeterminate and fill the gaps with the best solutions and the best disciplinary approaches that we can find? Even though it might seem natural to us that the law develops its own hermeneutics, which is somewhat autonomous from other discourses, it's anything but. The autonomy of legal doctrine is not a conceptual feature of the law, but a cultural accomplishment which took centuries to develop. The development of the law as a distinct social practice has been a gradual process. This process included the development of a specific set of institutions and procedures, but also the development of a specific hermeneutical practice of legal doctrine. Taking them as ideal types, and I can only underline this, as ideal types, especially with so many historians of law in the audience. My interest in history is just to kind of lay out some ideal types and to abstract from the intricacy of historical accuracy. Talking of them as ideal type, the distinctiveness of legal institution and procedures on the one side and the development of an autonomous legal doctrine on the other can be exemplified by the differences between the ideal types of ancient Greek and classical Roman law. The Greek legal system knew various types of courts and legal institutions. The different courts had quite a diverse menu of legal procedures. For example, there were at least 3 court procedures in place regarding the performance of public officials. One, at least in the higher offices, it seemed that there was a mandatory judicial examination of the term. The second procedure was a public prosecution for not reporting or not delivering the required reports, which could be brought by any citizen. And then there was thirdly a real impeachment procedure for any kind of malpractice committed in the office, which could also be initiated by any citizen. And ancient Greek law had also written laws. So ancient Greece had all the core institutions of a legal system in place. They had different courts, very specific court procedures, and written laws. But they lacked every feature that is a prerequisite for developing an autonomous legal doctrine. They had, for example, no legal terminology. As Stephen Todd, one of the leading scholars in the field, remarks, quote, Athens had no truly technical legal language. The language of the law was the language of the street, end of quote. They had no rules for legal interpretation. They did not even have a hierarchy of legal norms. To quote Todd again, until the end of the 5th century, there was no hierarchy of norms. All legal statutes carried in principle equal authority. Any resolution of the 5th century assembly was as much a nomos. This means any decision by a court assembly was a norm that could overrule any other predating law. The parties to court procedures had in principle to speak themselves, with little evidence even of rhetorical legal training. The lay judges reached their decisions, I quote again, without conferring and without any instruction in the law by legal expert, end of quote. The whole idea of legal expertise was dubious in the Greek legal system. Todd reconstructs the procedure against Nicomachos, of which a forensic speech by Lysias has been recovered, as a trial in which the reproach has been the legal expertise of Nicomachos. I quote Todd again, Athenians disliked expertise. Knowledge is power. And to be an expert in law is to have a threatening access to legal patronage. End of quote. He concludes that if Nicomachos had been convicted, we don't know. We just have this one speech. Despite the, in our contemporary eyes, weak evidence, I quote him again, his would have been the fate of both an expert under Athenian law and more specifically of an expert in Athenian law, end of quote. Continental scholars of the last century have often bemoaned the lack of legal and doctrinal standards and rule of law standards in Greek law. But the more recent scholarship regards this as an anachronistic perspective. In ancient Greece, the law was considered a thoroughly democratic enterprise. It exemplified the Greek tradition of open public debate and discussion among a large segment of the public. And in this public, reliance on specifically legal arguments was seen as an inappropriate claim of specific discursive powers, and that is as the power grab for what it is. Even though early Roman jurists were influenced by Greek philosophy, the Greeks did not apply their philosophical methods to their own law. They resisted the development of autonomous legal doctrine. Instead, each party's substantial arguments were supposed to be heard. No party should be able to claim to have a special legal argument to gain an advantage. When Socrates was accused of corrupting the youth, he defended himself not with a legal argument, but with a speech about the true nature of education. He pleaded his case as a scholar of education, not as a lawyer. However, the details of ancient Greece law, and there are still considerable gaps in the sources and our understanding, ancient Greek law allows us at least to imagine an ideal type of a legal system different from ours that does not rely on an autonomous legal doctrine. When did this change? It was only at the dawn of the classical period of Roman law that specifically legal arguments and an autonomy of the legal doctrine started to develop. The Roman jurists of the pre-classical period started to create their own system of doctrines, which set them more and more apart from priests and political rhetoricians. It were these early Roman legal scholars who systematized legal materials and developed the law by working on hard cases of their time as counselors to parties and to magistrates. In his book, The Rise of the Roman Jurist, Bruce Fryer traces this change in a passage in Cicero's oration Pro Caecina. It's about 70 BC. However, Cicero still has to argue for the relevance of doctrinal legal arguments. And let us listen for a moment to Cicero. He says, "It also appears strange to me in this oration. It also appears strange to me that a statement should often be advanced in courts of justice and should be sometimes even defended by able men, that one ought not to be always guided by lawyers, and that the civil law ought not always to prevail in the decision of causes." End of quote. So Cicero still encountered it often that legal arguments from lawyers should not prevail in court. He argues strongly against this tendency. Cicero again. If they admit that the lawyers give proper answer and still say that different decisions ought to be given, then that is saying that the wrong decision ought to be given. End of quote. It is at the time, it seems, not self-evident that the proper answer of lawyers should decide the case. For Cicero, very different from ancient Greece, this is not a minor problem. Or to quote him again, "For he who thinks the civil law is to be despised, he is tearing asunder the bonds not only of all courts of justice, but of all usefulness of common life. If he thinks he ought not to be guided by learned men," that means learned lawyers, "then he is not injuring men, but he is undermining law and justice." End of quote. Law and justice for Cicero depend on the prevalence of civil law doctrine over other kinds of arguments. Unlike in ancient Greece, the arguments used in Roman legal disputes were increasingly categorized as either specifically legal in nature or not, and eventually only those arguments classified as specifically legal were accepted in judicial proceeding. This development has influenced the common law as well as the civil law tradition. They have taken up the Roman heritage in different ways, but they both kept and further developed the autonomy of legal doctrine. They kept up the differentiation between legal and rhetorical, political, economic, and ethical argumentation. This process of social differentiation led not only to the autonomy of legal institutions, but also to an autonomy of a system of legal doctrine that determines the validity and quality of argumentative moves in and around legal institutions. At least in developed legal systems, such as the Western ones, the complexity of the institutions and the legal material these institutions have produced have reached a level at which arguments of other discourses cannot be introduced into legal discourses as such. Even though this autonomy of legal meaning is contingent in the long historical perspective, as we have seen, it is a defining feature of developed legal systems in functionally differentiated societies. The differentiation is not only based on the specific binary code of legal versus illegal, as Niklas Luhmann has stressed, but has also developed its own discursive structure in which arguments count only if they are presented as doctrinally valid ones. To exaggerate, one could say that disputes are decided not on the basis of considerations rooted in the real-world substance of the conflicts, but exclusively based on doctrinal legal rationales. At first glance, and in view of the real-world problems we face, this is an astonishing development, isn't it? People have relationship problems, financial problems. Now we have a lot of supply problems. But we don't have doctrinal problems. As an estranged married couple has a relationship problem first, not a legal problem. An over-indebted company has a financial problem at first, not a problem of bankruptcy law. They do not have the problem of whether a particular statute should be interpreted in a literal, originalist, or teleological sense. But the law transforms relationship, financial, and supply problems into hermeneutic doctrinal ones. It develops its own criteria to address them, criteria, though oriented towards these real-world problems, are by no means always the same criteria as subject matter experts would recommend. The law decides whether or not a marriage is irreversibly broken to justify a divorce according to doctrinal criteria, which differ considerably from those of a family psychologist or a marriage counselor. Similarly, under bankruptcy law, a company is treated as viable or not based on different criteria than those applied in the financial and economic sectors. So, Ehrlich's question is still acute. Why should modern societies, with their huge repositories of highly specialized knowledge, be willing to make decisions not by way of direct access to these resources, but instead by means of a reservoir of doctrinal arguments arcane to all in society except those with a professional legal training? Why don't we let marital conflicts be decided by psychological experts, bankruptcy issues by economic experts professionally qualified in these issues? Why accept, in other words, that some marriages will be declared irreversibly broken under the law, even though from a psychological perspective they could still be saved? Why accept that some companies will be liquidated according to bankruptcy law, despite them still having prospects in the market? Or more broadly, why do Western societies risk producing results that are suboptimal from the subjective matter expert's perspective in order to indulge in doctrinal hermeneutics that it is at least to some extent removed from the substance of the issues? The artificiality of this development is ever more astounding because of its wide-ranging scope. The autonomy of legal doctrine has not only developed as a quirk due to some special contingent historical developments in one legal system in one country, but in varying degrees in all modern legal systems, at least of the Western type. Thus, it can hardly be written off as an historical accident. There must be more to it. It must serve a function for these societies. Now let me try my grand social differentiation thesis, which shares the disadvantages and advantages of theses of this kind, namely that it can hardly be empirically proven or disproven. I think, however, that my thesis has quite some plausibility, and this is probably all that we can aim for at that level of abstraction. The reason for the probably costly development of an autonomy of legal doctrine can be seen in the fact that the transformation of substantive questions into legal questions allow Western societies to perform a kind of a miracle. It allows them to sustain a seemingly paradoxical state of affairs, namely that each conflict can be decided authoritatively at any time, in any place, by the law. And at the same time, the societal discourses, whether they are scientific, moral, ethical, economical, aesthetic in nature, can remain open. In a way, the autonomy of legal discourse allows our societies to have the cake and eat it too. Wherever necessary, courts decide conflicts authoritatively at any instant. But in doing so, they do not, in general, decide on scientific theories, historic facts, morality, ethics, economics, what have you. Even if a court declares a married couple divorced, the ex-spouses can try again with the couple therapist. They are free not to consider their relationship irreversibly broken, even if a court has just declared it so. Even if a constitutional court rules that abortions are constitutional under certain circumstances, people can continue to argue that abortions are unethical. The added value lies precisely in the fact that the law can, when a decision is needed, decide any conflict arising in a society at any point in time and any location within its jurisdiction without deciding on the substantive, psychological, economic, ethical issues, but only on the hermeneutic legal ones. That the creation of an autonomous legal doctrine allows us to keep all other areas of discourse open is like every other rule, not without exception. But the exceptions and the irritation these exceptions produce corroborate the rule. One exception are the criminal rules against the mere denial of historical genocides in some jurisdictions. As much as one agrees with the historical assumptions and the protective intentions of these rules, something feels off when the law decides on historical facts, a business we usually relegate to the history departments of our universities. But rules and legal doctrines like these that try to decide issues in substance are rare. Generally, authoritative decisions in the realm of legal doctrine leave the other societal discourses unaffected. They can continue to sprawl, develop new and contrarian ideas, and stay innovative and vibrant. This also allows for dialectical relations between legal doctrine and other areas of discourse. Scientific, ethic, and economic discourses will keep developing despite authoritative decisions on their subject matter in legal doctrine. The developments in these other areas of discourse may then influence later legal decisions, amending, changing, or even reversing legal doctrine. If courts were to decide authoritatively on historical, psychological, economic, and moral issues, societies would lose much of their openness and dynamism. The authoritativeness of their decisions would carry the risk of stagnation and even petrification of important fields of societies. In the development of Western societies, this appears to be the advantage in exchange for which societies were and are willing to accept, and to a certain extent, that legal decisions are oriented and guided by an arcane hermeneutics of legal doctrine. Let me finish by illustrating my thesis with a recent case in point. In the debate about vexation mandates, the societal differentiation advantage of having specifically legal decision and regulations seem to have been lost from view, at least in Germany. There was and is a widespread agreement that the only effective way to fight the corona pandemic was to achieve a high degree of vaccinations. Although billions of administered vaccinations proved otherwise, some still doubted both the medical efficacy and the medical safety of vaccinations. Others continued to regard not getting vaccinated as a legitimate expression of their individual freedom, despite the obvious dramatic consequences of insufficient vaccination rates, such as continued lockdowns, school closings, and higher mortality rates. Policymakers attempted to overcome, in Germany at least, to overcome this resistance by asserting medical truth and moral certainties in an authoritative manner. They hammered the scientific facts about the vaccination, and they considered it a moral imperative to get vaccinated. This meant that vaccination skeptics and vaccination opponents had to be branded as obscurantists and immoral. Politicians had to set the high moral note. They tried to shame people into vaccination. There was even the talk of a tyranny of the unvaccinated. Politicians had to set the high moral tone because that is unavoidable when policymakers try to authoritatively decide on scientific and ethical conflicts. It follows then that open discourse and opposition can no longer be tolerated. Instead, policymakers should have used the same means that Western societies have relied on ever since Cicero's pleas: the law and legal doctrine. Legal vaccination requirements would have to lay claim neither to scientific truth nor to moral irrefutability. Anyone would still be free to dispute a legal vaccination mandate using pseudo-scientific arguments or to question whether the requirement is ethical. Shifting the decision into the sphere of legal doctrine would have had the effect of unburdening other discourses. Policymakers would no longer have to shame skeptics and to seek to stigmatize them by excluding them from public life. The growing epistemic, political, and ethical divide would not have been further exacerbated by the state as it has been done. Let me conclude. Early legal sociologists, such as Leona Petrażyckiego, François Genis, Eugen Ehrlich, were right to challenge the doctrinal orthodoxy of their time. And Eugen Ehrlich was right to ask the question why one would leave it to the artificial and arcane standards of an autonomous legal doctrine to decide the most practical issues in cases of legal indeterminacy. However, I think that there is an answer to Ehrlich's question. Thank you for your attention.
Thank you, Professor Poscher, for this interesting lecture. And we have usage here that after the lecture we have a small round of discussion, not very, but I would like to ask the audience not to make very long, how to say, co-referates, but only to put questions or also the signs of how to say, disagreement also, but very, very substantial and very, how to say, very concrete. Is there anybody who would like to say something? Professor Matczak, maybe you will bring, yes.
Professor Poscher, thank you very much for the lecture. Two questions. The first one concerning a distinction Fred Schauer made in his book Playing by the Rules. He said that when lawyers are confronted with hard cases, it is impossible for them to follow the rules. So they tend to use so-called all things considered approach. I have heard today, I think, that probably there is something in between. So not the rules only, but all things considered would lose totally the autonomy of legal doctrine. So my question is, what can be between the two? So if we are not able to follow the rules or play by the rules because the text ran out, but on the other hand, it would be difficult to use this all things considered approach because that would be to think as lay people think, I understand. So what is in between? And the second question, what or how you see the role of non-legal experts that are involved in legal decision making. I understand that there are two possibilities here. We involve them in the matters of fact, because we need doctors, for example, in criminal cases. We need technical specialists in traffic accident cases. But sometimes they are involved, I believe, in creating the doctrine as well. In antitrust law, for example, we need the economists not only to state the facts, but to help to shape the doctrine. In tax law, when we have the beneficial ownership concept, which is a doctrinal concept, we need economists also to help us. So how do the non-legal experts fit within your theory and what you've been saying? Thank you very much.
Fine, I can answer immediately. Yeah, thank you for both questions. I try to describe just the in-between, and it depends on the subject matter, but I think you have all kinds of legal standards, doctrinal standards that you employ in this in-between, and where you have to make decisions, also on legal standards. For example, the examples I gave was, do you rather interpret certain constitutional rules unitarily because you favor a less federal approach to problems, or do you interpret them more in a federative sense, for example? And this might be decisive on the issue, but totally abstracted from the substance of the issue. It might be like they have now a case in, I don't know if you read the paper today, there's a case about California banning the import from other states of pigs that have been maltreated in other states. So you can be on the animal rights front, whatever side you're on. The decision will be taken on how do you interpret the Due Commerce Clause. And this is not in all things considered, and it's indeterminate. It's in the Supreme Court, and court have issued different opinions on this. And whatever your position on animal rights is, the question will be decided by totally doctrinal evaluations and thoughts and standards that have nothing to do in the end with the pigs that are in play. But the people there, for them, it's all about either importing pigs and producing them in other states and being able to sell to California, or to protect animal rights. But the decision, even though it's indeterminate, will be taken on a totally different level. And it's not an all things considered decision, but it's a decision on how do you want to structure the federation in the United States, for example. So that would be one of the in-between things, that there are specific doctrinal aspects that will lead the way in these discussions, which are not all things considered. And then if you're more an originalist, you will dig into the sources and find something, just what Ehrlich made fun of, this pitiful work that lawyers have to do, instead of arguing about animal rights. So I think that is how this very much differs. And I can also give you what was very instructive for me once was, you mentioned my academic teacher, Bernhard Schlink. He was also constitutional judge for quite some time in North Rhine-Westphalia. And I remember he had one case where the North Rhine-Westphalian government merged the inner ministry with the Ministry of Justice, which would have given the inner minister the oversight over the courts that do the oversight maybe of his police forces. And so people thought that was a terrible idea. And we all thought it was. The question was whether he could do it without parliamentary legitimation. And we used to discuss these cases, and everybody in the room thought that was a terrible idea, and there would have been a way to argue against it. Because there was a doctrine, kind of an essential decision doctrine that the Federal Constitutional Court developed, that in essential questions the legislator has to decide. But it was such a vague and open to misuse doctrine that we all disliked this doctrine. So even though everybody thought it was a terrible idea, there was a route to come to the desired result. 10 people in the room, they all opted for not employing the doctrine for doctrinal reasons. In the end, the court decided against my academic supervisor, and they required and they made use of this essential doctrine. But it was a very significant an occasion where you could see that even if there is a doctrinal way, there are doctrinal commitments you have that you do not sacrifice, even though you think that would in the substance be the better substance of this case would be the better decision. So I think there's a lot of in between, and this is where legal doctrine sits, and that is what we teach our students to work with, and not just all things considered. And the second thing, the legal expert, that's really interesting. I think the fact side I haven't even talked about. I think sure, they are totally involved. I think, and lawyers are very much dependent on them. But I think you're totally right. We also make use of experts to develop our doctrines, because autonomy is fine, but autonomy is never independent, and law cannot stay behind significant societal developments or scientific developments. So I think one of the jobs that academically trained lawyers have is just this, to pick up these pieces of new knowledge, of results that are developed in other discourses, and to try how can I integrate them into the doctrinal system. Right? But you cannot take the expert and say, well, then you tell us how to decide the antitrust case. No, you have to have the expertise, and then the doctrinal lawyer has to say, okay, how can I make use of it without wreaking havoc? If I do it in tax law, this might be in the law of mergers, and in the law of in competition law might be a total disaster if we say whatever, because the doctrines are so interconnected. And I think that is also what we train our academical lawyers to do, and what only they can do. And it is their job, I think, to integrate all these new knowledge parts that the law is confronted with, to find ways to weave it into the doctrinal structures. And it's a very delicate work, and that's why it takes, I don't know how long it takes in Poland, but in Germany it takes like 6 to 8 years to become a lawyer. It's for a reason. But I think that is mainly the reason why, and that is why we train them on hard cases. We always push them. How can you do this? How can you develop? And then we give them cases where new problems come up and where new arguments are presented. And can you weave them into the doctrinal structure? That is the job, and that is where we train them. And that makes a good lawyer, that he's able to. But as goes the saying, if you can always do it as a lawyer, you're a bad lawyer, and if you can never do it, you're a bad lawyer too. So it's also again this in between. Yeah. Thank you.
Thank you very much. Yes. There is another discussant. Please tell us your name.
Marcin Romanowicz, thank you very much. Professor Poscher, thank you very much for sharing with this very interesting enterprise project of the autonomy of legal doctrine. Let me ask you about your concept of legal doctrine. What is the logical status of the legal doctrine statements? Are those normative, namely rules, norms, or descriptive? They describes the content of law. In other words, what is the function of legal doctrine? The legal doctrine is discovering the deeper understanding meaning of the law, hidden meaning of the law, or maybe legal doctrine is constructing the content of law. Thank you.
Yes, thank you very much for this question. I think it's an important one to clarify. And I think it can be both. In cases where there is an established legal doctrine, or the cases that I did not talk about of legal determinacy, it can be a process of discovery. But I think in the cases that I talked about and that Ehrlich was concerned of legal indeterminacy, it's a question of construction, and this construction is normative. And sure, as an academic lawyer, you cannot set norms, but what you do is you make suggestions for courts to issue certain norms and to amend laws with certain doctrines which are normative. So I think it's a normative enterprise. And it's not a descriptive one. Yeah. So the status is it's a normative. Doctrines are normative.
Thank you. The next is Professor Stawecki.
Professor Poscher, thank you very much for the very interesting lecture. And I would like to have first very brief comment to the previous question. Your position of legal doctrine having both descriptive and normative character was also presented by Alexander Petrażyckiego with the paper of 2004, Can Philosophy Help Legal Doctrine? And he says directly, legal doctrine is in a basic role descriptive, but it also does justice, and does legal practice. But this is just a question of margin. I would like to ask two questions. First, let's say, historical one relating to Petrażycki, and the second, socially oriented. The question to Petrażycki is the following. When I was reading Petrażycki quite systematically as a young scholar, I had a feeling that I understand him because his main works, not the first German books, but the following books written in Kiev and in St. Petersburg, etc., were written in a country where less than 2% of people had ability to read. And the access to statutory law was practically impossible for a subject, I wouldn't say citizen, but for the subject. And if you have such social contexts, the fixation on the legal experts, on the doctrine, is just kind of job without good end, without good result. And I found the same story many years ago in a quite well-known musical and film, Fiddler on the Roof. In one of the pretty end facts, there is a local policeman who comes to Anatevka, to the village, and says to villagers, "You must move. You must leave Anatevka in 2 weeks." One of the main character, Tevye Milkman, says, "Why we have to leave Anatevka?" "Because there is an order," says policeman. And it sounds like no argument at all. My only argument, I have no social argument, philosophical, religious, any other argument, except because there is an order. So maybe this is the kind of skepticism of Petrażycki and Eugen Ehrlich to legally oriented approach to hard cases. And the second question, very short, is referring to social context of performing and application of the law. Do you take in your consideration, in your research, do you take into account two issues? The issue of legitimacy of law in a given country, and the question of trust as the certain social relation between people and between ruling and ruled. Okay? Because in Poland, both legitimacy of the government, of the legal system, is very low, And the trust is, as sociologists say, I'm not a sociologist, as sociologists say, is one of the lowest in Europe. Thank you.
Thank you. Yes, as for Petrażycki, I just didn't have enough time to see, and I'm not sure what he wrote in this domain of, or what his thoughts were in the domain of legal methodology, how to apply the law. So because with Ehrlich, it's a large part of, or it's one part of his work where he got famous for, as one of the founders of the free law movement in Germany, which was then picked up by the American realists and what have you, the whole story. So, and I don't know what Petrażycki's position there would even be. But I think they are sure united in this idea that state law is something that comes last. And I always had some sympathy for this idea, and I could easily see that in other historical circumstances this makes even more sense. And for Ehrlich it was a special situation in the Bukowina where he saw there were different religious communities, and the Austrian law didn't even play a role. I mean, there were all these laws, but nobody applied them. They all had their community rules, and they lived by them. And so for him, it was evident that state law is something, above and beyond. So I can easily see how historical circumstances like this can promote these ideas. And I could easily imagine, as you describe the circumstances for Petrażycki in Petersburg with a low literacy rate and what have you, probably similar things were going on. And legitimacy and trust, I mean, sure, legal systems, they will depend on that, that they need a certain amount of legitimacy and trust to function, I think. But this is not the topic of this talk. It's rather what a developed system that functions, why does it function and how can it function in the way it does? No, what is the reason why it's set up in this way when it functions well? So it's not so much the concern whether the system then is legitimate or not. I think is a basic sociological fact. I think you need a certain degree of legitimacy of whatever sort, and be it just oppression, authority, what have you. But it's more the question, once you have a system and you observe that it has the tendency to develop an autonomous legal system doctrine, why is that? Because it's, I think, such a curious development for all, even the legitimate systems, to have.
Next question. Yes, Jakob.
Yeah, thank you so much. I've, of course, a lot of sympathy for your ideas because they're very reassuring for us lawyers. No, we can justly feel important again, and we are doing what we are supposed to do. So I only have two more or less footnotes or remarks. The first of all is from my Chilean experience and concerning the culpa in contrahendo, which is of course one of the great achievements of German jurisprudence in the 19th century, and in Chile they love it. And now a friend of mine translated this very difficult article of Jering in this 19th century German in Frakturschrift and so on into Spanish because this doctrine of culpa in contrahendo was adopted by the Supreme Court of Chile, and they felt that they somehow have to justify this. And how do you justify it? You cannot say, because Professor Barros writes this in his book, and Professor Barros writes this in his book because he did a PhD with Arthur Kaufmann in the 60s in Munich, and so he's able to read German and just imported these ideas. So this would be no justification at all. So in the end, they did a little bit the same what Jering did, quoting all those things from the digest and so on, which are difficult to read, difficult to understand, in order to legitimize culpa in contrahendo in Chile in the 21st century.
Fascinating, yeah.
And the second one, of course, I very much appreciated your incursions into or use of legal history. There is one of the greatest books, maybe you've come across it, of Roman law, is by Doctrine, Rechtskritik in der Antike, Legal Criticism in Antiquity. And there is a famous case which is guardianship over women. So women were either under the guardianship of their father, of their husband, or especially appointed guardian. And Gaius, who wrote a small manual of introduction into the law, makes fun of it and says, this doesn't make sense anymore. Women are perfectly capable of managing their own estate. Why would they need a guardian who is appointed for that? So this is in a certain way, this approach which you explained here, you have the law, you have to apply the law, but you're free to criticize the law. And this is what I always taught my students, because abortion, for example, was a great issue in Chile. And I was giving the course of Introduction into Law. And I said, well, here at the moment we have the Constitution of 1980, which was done under General Pinochet, and we have to accept the Constitution as it is. And under this Constitution, abortion is only possible in these 3 exceptions, which we all know. But of course, if I don't like this, I have to get off my frock of professor, take to the streets and organize a political movement in favor of a liberalization of abortion. But I cannot preach here as a professor, if I want to, a violation of the Constitution. Thank you.
Yeah, I take this as rather supportive comments, and I really like this story about Chile and that they had to go through the same moves that Ehrlich was criticizing. And Ehrlich would have said, why can't they just say that's smart to do, that's just a good way to regulate these problems? They can't. They have to come up with something, and then they do the same as Jering had to do. So it's a wonderful story, and if you have a source for this, I would definitely put it into the footnote. Yeah. Mm.
May I put a question, maybe, or not really a question, or well, let's see. Anyway, you have started from the concept of hard case and so on, yeah. Hard case. What is hard case? This is a little bit mythical. I have interested myself for hard cases, clear case, and so on. For me, the most evident hard case is a political case, because political cases has always at least 2 solutions, or maybe more solutions than. And as a matter of fact, as you mentioned, this civilizing merit of inventing law as a instrument of solution of social conflicts, yes, because it as a merit of Western legal tradition that we have invented, we in the West have invented this method, say, of resolving social conflicts, and we send a guy to the court, and the court will tell him what is what is right and what is wrong. Okay, but now it can be in an abstract sense very correct vision of the things. But I would like to say now we observe a really reverse phenomena, how to say, a contrary tendency. For instance, the famous, you will know the doctrine of Carl Schmitt about the judicialization of politics, that there is a constitutional court and they will tell you, but normally it's only a, how to say, already in the legislation there is this, how the Schmitt defined it, dilatory compromise. Yes. Now we cannot decide because there is one fraction in the parliament, there is another one. So we will vote a law, a statute which is very indeterminate. Yes, and then the constitutional court will tell us what is to do. And now we observe really a method also in the European Union to I would say to use this method, which was already criticized and was already it's not my invention, how to say, my discovery, governing by judging, or how to say, politicization of judiciary. It was the outcome which Carl Schmitt already prophesied for this method of sending all the things to the Constitutional Tribunal. And for instance, we have in the European Union, we have since many decennies the problem: do we want more European Union or do we want less European Union? And the European Court of Justice had very long time always represented the theory that we need more European Union. And this was also, this met with protests also in Germany and from the German Constitutional Court. And but I don't want to criticize neither the European Court of Justice nor the German Constitutional Court, but anyway, it is typical political question, which is decided in the legal order of the European Union, is decided by the court. And this court, I have studied a little bit the problem, and the president of this court say always, we must how to say, divide politics from legal problems. He told it in many papers, because he always writing. He's always also a legal writer, not only a judge. He's also a law professor and so on. So at the end, we have a little bit a problem. How to say that this method of solving some social problems by means of a court is also imperfect. And then we have always the problem of politics, which comes back every time. Yeah? Mm-hmm. What do you think about it?
Yeah, I think one can definitely overdo it, and just to pass all the political or hard political problems into the judicial realm and have it then decided, either by a type of jurisdiction that does not really adhere to or does not really care much about the development of a doctrinal sphere of argumentation that is distinct from politics, but which is very close, that they tend to have all considered arguments, everything considered arguments, that they decide many questions not by digging into the sources, coming up with a theory about what have you, but rather by weighing certain interests at stake, and then the law can also lose this quality, and then it can become very close to politics. So, and this was also when I told you this anecdote about when we were talking about this case of my academic teacher. That was what was pushing us against accepting this essential doctrine, because it was so vague that it was could easily be used to do these all considered arguments, which then are hardly distinct from politics. And there are some courts that fall into or that fall into the trap of doing something like this, or that empower themselves. But I think they do it very often by not taking much care of developing a really autonomous sphere of legal doctrine, but rather by reverting to formulas of weighing interests or doing all considered arguments. And so that's on the one side of overdoing it. On the other hand, I once designed, together with colleagues, a master code for the law of assembly. And we were sitting there, we had like 10 sessions where we met over weekends, and then we discussed everything. And there was one of my colleagues, he always came up with a case, okay, but if we formulate it like this, what do you do in this case? And then he came up with a very, very strange and artificial case. And you very soon, you reach the point where you say, okay, no, stop. This has to be business of the court. Should ever a case like this arise, we don't make an exception for this in the code, we just leave it to the courts. So I think there is some legitimate referral to have these problems solved by jurists doing their doctrinal work. And you can't regulate every thinkable detail, because then regulations will become unmanageable. So I think there is this dilatory compromises which we made in these. We didn't do it in the big questions, but in the minutiae we did. We thought, oh no, that's too late now. We can't do it anymore. Let the courts figure it out when they get a case like this. And I think that always happens in legislation, and has to. You have to regulate the main and a kind of the paradigmatic cases, and for all the fringe cases, that's business of the courts, and that's what they're there for. And then they have to try to figure out a consistent doctrine for these issues.
But may I
Sure.
insist a little bit? For instance, in my opinion, there is a change after the Second World War in Europe, after we have received the constitutional jurisdictions, yes, from America, more or less, and that let's say the number of cases which are considered court cases, because in the traditional doctrine, before the First World War in Germany, for example, there were cases with which you can go to court and you cannot go to court. There is a word in German, justiciable. Yeah? There were things which were justiciable, and there were things which you were expected to take your discontent with you, and not everything can be decided by the court. And after this huge career which was made by the constitutional jurisdiction and constitutional judiciary, constitutional courts, people present all the things to the constitutional court, at least. And is it a good trend, in your opinion?
As I say, you can also overdo it, and there are people who are decidedly of this opinion that this has been done. I don't know if you have noticed, but my colleague Martin Lachlan, he just put out this book Against Constitutionalism, where he describes the development just like you did, and he opposes it vehemently because he thinks they have gone much too far, and it has led to constitutionalization of politics in a way that is not good for these societies. So you can overdo it, no question. Yeah.
Okay. Is there anybody who would like to pose a question or to say something about the lecture or about the world outside? No. Nobody. So I would like to thank you, Professor Poscher. It was very interesting. Thank you also to the public, because it was our Petrażycki lectures were a little bit in a crisis because of the pandemics, more or less, and we had one which was online lecture, and then normally we had always some of small booklet, yes, with the lecture itself and with the lecture in English, with the lecture in Polish. But now we have started to how to say, to improvise, and now without this booklet, there was a relatively much public, and this audience was very qualified as well. Thank you very much. Thank you, Professor Poscher. Thank you for